Assalamualaikum warahmatullahi wabarakatuh. So this is our second part of part 2 of the lecture, okay, for Law of Contract 2, Law 111, for the topic mistake. Okay, in the previous part, which is part 1, okay, I have covered up until these slides basically. Okay, we discussed earlier on about here, okay, we were here. We discussed about the position of mistake under Contracts Act, okay, and then especially okay, circumstances, okay, situations, example of mistake of facts okay, made by both parties. Yeah, okay, let me just, all right. So it may occur, okay, it may happen in the following situations. Example, okay, of the circumstances or situations. Okay, for example, the first one, mistake with regards to this to the existence of the subject matter of the agreement, especially the one which is covered by the illustrations. Okay, all the illustrations under section 21. Okay, it talk about mistake with regards to the existence of subject matter. And then a second category, second type is mistake with regards to identity of the subject matter. Okay, we are going to discuss after this, especially the case law, right? These are the cases. And then the third one, mistake with regards to as to the quality of subject matter. Okay. And then the last one, mistake with regards to the possibility of performing the agreement. Okay, let's move further. We discussed about this actually. Okay, section 23, we talk about not voidable. Okay, the effects of the contract. All right. So basically, the meaning is interpreted as valid. Okay, not voidable means valid. Okay, all right. We go to the first one. Okay, mistake committed by both parties. Okay, the first one is mistake as to the existence. Okay, the existence of subject matter. All right, we have read together, or you can refer to your Contracts Act illustration A, B, and C. Okay, all right. So all the illustrations in section 21. Okay, basically it discusses or describes about this. Okay, here when unknown, okay, to both parties, meaning that both parties are not aware. Okay, the subject matter of the agreement had ceased to exist, no longer in existence. Okay, or actually has never been in existence at all, never exists from the very beginning. Okay, at the time of the agreement, when they entered into the agreement, when they signed, when they executed the agreement. So what happened to their agreement here? The agreement is considered as void. It is void, no effects, not enforceable, okay, in the eyes of law. Okay, we have a classic case here, common law case, Galloway and Galloway, all right, 1914. Let's move further. Okay, what happened in Galloway? So basically, in this case, okay, we have a man and woman. That's why we have the same surname here. Okay, Galloway and Galloway. So a man and a woman, okay, they entered into a separation deed, okay, on the mistaken and common assumption. So both of them thought, okay, that they were in fact married to each other. Actually, they were not. Okay, they thought they had been married, but so later, okay, after some time, they wanted to get a separation deed. It's like the process before divorce here. So what was the decision here? Observation by the court, all right? The court declared the separation deed a nullity, null and void. Okay, here why? Because they had proceeded, okay, to apply for separation deed on the supposition, okay, or assumption that the subject matter of the separation deed, that is, the marriage was in existence. So basically, in order for the parties to apply to ask for separation deed, they must be marriage, okay, at the first place. But for this case, actually, they were not really legally married to each other. Okay, so their marriage, okay, their legal marriage was actually not in existence. So there's no way that they could apply for separation deed. So that's their assumption. I mean the mistake, okay, assumption here made by both of them. Okay, both of Galloway and Galloway here. All right. Okay, we are done with the first one. So that's second one, second situation in which mistake can be committed by both parties here. Mistake as to the identity of the subject matter. Meaning that here, all right, when it happens. So usually it arises, okay, where one party intends to deal with one thing, okay, and the other with a different one. I mean, they are mistaken with regards to the identity of the subject matter, not their identity. Okay, it doesn't refer to contracting party. It refers to the subject matter. Okay, all right. For example, A intends to offer his house in Taman Melati for sale, but B believe that the offer relates to the house in UK Perdana, also owned by A, meaning that A owns 2 houses and he intends to sell one of the houses here, but B thought he's selling the other house instead of the house that A really wanted to sell. Okay, so here in the situation, there is a mistake as to the identity of subject matter. So what's the subject matter here? It's a house. Okay, identity. So it refers to a house in Taman Melati and another one a house in UK Perdana. Okay, we also have one common law case on this subject matter on this issue. Okay, we have the case of Fogg and Williams. 1900. Okay, here, all right. Very old case. Here, what happened? Okay, the defendant and the plaintiff, both of them, they were negotiating, those days, a long time ago, about 2 charter parties. So there exist 2 charter parties here, right? It refers to certain vessel or vehicle, right? Usually ship, right, to carry a certain commodity. Yeah. So one of the charter parties, all right, the first one is to carry shale. What is shale? Shale is soft rock, right? From Sydney to Barcelona. I mean that different different subject matter and then different destination. And another charter party here is to carry copra. So what is copra? Copra is dried coconut. Okay, here I put the definition here, right? The dried coconut kernels. All right. So copra from Fiji to Barcelona. Okay, meaning that here 2 different things. Okay, and then to be I mean it's meant for different destination here, right? To be carried to different destination, different location altogether. So plaintiff's agent, sent a coded telegram. So those days they were communicating via telegram. Okay, a coded telegram intending to confirm the copra charter, the second one. Okay, but the telegram was ambiguous. It's not really clear. Okay, it creates confusion here. All right, contains certain ambiguity here. All right, and the defendant understood it to refer to the shale charter. So defendant thought the plaintiff wanted to have this shale charter. Actually, plaintiff wanted to have copra charter. All right. And then, of course, they disputed their agreement later, right after the conclusion of the contract here. So the court held that when the case was brought to the court, all right, the court held that there was no contract because of the confusion, okay, as if there's no contract at all from the very beginning of because of the mistake of the identity of the subject matter of the contract. Okay, the third category, in which circumstances, all right, whenever mistake with regards to, it happened to both parties, committed by both parties. So mistake as to the quality. Okay, the first 2, we have discussed identity, we have discussed existence. Now, what if the mistake is with regards to the quality? All right, so basically in most of the situations, the rule is that, the contract is still considered as valid. Okay, all right. If the first 2 situations just now, is considered as void, okay, not enforceable. Okay, now you need to refer to explanation to section 21. Okay, let me take my Contracts Act. Okay, I have with me my Contracts Act. So let's refer to explanation part, because section 21, you have illustration. You also have explanation. Okay, what does it say here? All right, it says, an erroneous opinion as to the value of the thing, which forms the subject matter of the agreement, is not to be deemed a mistake as to the matter of facts. Remember, requirement in order for a mistake to be operative, it has to be with regards to a matter of facts here. So if it is about so it doesn't say quality right here, but it says about value of the thing. So more or less, actually, it means quality. Okay, so we have the case of Smith and Hughes here. All right, Smith and Hughes, 1871, very, very classic case, old case, common law. So the court, this is the ratio that we extract from the case here, okay? That is a valid contract, okay, despite the mistake, okay? Because why? There is a mistake here, but then subject matter, which is oaths, only differs in some quality, not substance. So obviously it pertaining to syllabary of certain oaths here. And then there's certain confusion with regards to the quality of the oaths here. All right, so this is the facts of the case, Smith and Hughes. So we have C, complainant, all right, so he's a farmer. So he agreed to sell to D, okay, so who's D? D was a racehorse trainer, okay. So C here wanted to sell, agreed to sell to D, all right, a certain parcel of oats, okay, which both of them believed to be the old oats, okay, meaning that here, as far as oats are concerned, certain oats are old oats, okay, but other oats are new oats, and it has this kind of oats actually has different purposes, okay, different usage altogether. So actually, there are in fact new oats, okay, whereas D here required old oats, okay, right. So there are in fact new oats and unsuitable for the purpose for which D wants them. Actually, D wanted to buy these old oats, okay, all right, for his racehorses. So later the dispute was brought to the court, all right. So the court held that, well, that is a valid contract, okay, despite the mistake, because as the subject matter only differs in some quality, not the substance. So the court looked at the the court looked at the subject matter, oats here. Is it the same oats? Okay, is it I mean, you still receive the oats anyway. Okay, and then both oats actually you can still use it even though you are not using it for your racehorses. Okay, so maybe you can use it for your own purpose whatsoever. So that's what the court decided in this case. So the emphasis is on the oats. Okay, not really the I mean, you still receive oats. You don't receive rice or you don't receive barley, for example. You receive oats. So still the contract stands lah. Okay? So that is a valid contract as far as the mistake was concerned. But actually, if you look further, okay, even though this claimant, all right, I mean, the party, all right, the plaintiff here, maybe he failed in the claim, all right, for the argument, okay, in his argument for the topic mistake, maybe he could try to argue other topic. For example, misrepresentation. Okay, remember, provided there exists misrepresentation on the part of the other party. It depends, okay, on the situation here. Okay, on top of Smith and Hughes, okay, we also have another two cases, both from common law. Okay, we have the case of Kennedy and Panama, okay, etc. Royal Mill. This is a very old case, 1867, 19th century case, and we also have Bell and Lever Brothers Limited, 1931. So for Kennedy and Panama, it's about shares. Okay, sale and purchase of certain shares here, and then for Bell and Lever Brothers, it's about some employment contract. So that's the dispute basically. Okay, it revolves around shares, and then here it revolves around employment contract. Let's move further. Okay, Kennedy and Panama, what happened here? All right. So plaintiff applied for shares in a company, okay, on the faith of an untrue statement, okay, that the company had secured a contract to carry mail from the New Zealand government. So when he applied for the shares, okay, so he relied on this untrue statement. All right, so he applied, he wanted to buy shares lah basically. Okay, so the shares were allotted to him. Okay, I mean, he got the shares. Okay, he purchased the share and he was given the shares. Okay, and later, okay, the contract with the government fell through. Okay, it failed. All right, it didn't get through. So the shares fell greatly in value. Of course, it affects the value of the shares that he has bought. All right. So because of that, plaintiff, okay, sued the defendant to take back the shares and refund the money. He said, no, I don't want this share. Because why? Because of the contract failed, so I wanted to get back my money. Please refund my money. Okay, all right. So, all right, got it. Okay, I hope you can hear me clearly. Okay, all right. Okay, so maybe let's move nearer. So plaintiff applied for shares in the company. So but this is the, yeah. Okay, all right. So plaintiff applied for shares in the company on the faith of an untrue statement. This is the observation by the court here, all right, of an untrue statement that the company had secured a contract to carry mail for the New Zealand. Sorry, we have done this. Okay, sorry. Okay. All right. How to... Okay, all right. So this is the observation by the court. All right. So basically, the court, I mean, the argument wasn't accepted by the court. So plaintiff was unsuccessful. Okay, because why? Court look at the shares. Okay, did you receive the shares that you bought? Okay, here. So the shares that the plaintiff had received, okay, or not, okay, because of the difference in value, different, okay, from in substance from those that the company had contracted to deliver. So basically, you still get the shares that you first bought. So of course, okay, you have to anticipate that basically the value of the shares fluctuates, okay, goes up and down very fast. Okay, all right. So you can't ask for a return, okay, because of the you are not happy with the value of the shares. Okay. All right. For Bell and Lever Brothers here, we have few slides. Okay. All right. Okay. So I want to get back to the earlier slides. Hold on now for a while. Okay, Bell and Lever Brothers. We are done with Kennedy and Panama. Okay, we are here, Bell and Lever Brothers. Okay. So what happened in Bell and Lever Brothers? Yeah, for Bell and Lever Brothers, Mr. Bell, okay, so he was the managing director for 5 years, okay, of a company that was owned by Lever Brothers. So meaning that here, he was the employee, basically, and the post was managing director. And then during his employment, okay, Mr. Bell here had traded for personal profit. Okay, so he did something during his employment, which was contrary to his contract with the company. So he's not supposed to trade to do this personal arrangement whatsoever here, all right, for his own personal gain benefit. And then, without knowledge of this, okay, without knowledge of what Mr. Bell had been doing here, okay, the company, the employer, Lever Brothers Limited, made an offer of redundancy. Okay, it's like in Malaysia, I think the term we use is VSS, Voluntary Separation Scheme. I mean, whenever you are made redundant in the year, the company offer you to resign, okay, from the company with certain payment of compensation. So here, he was given an offer of redundancy, okay, to Mr. Bao, terminating his contract and offer him to pay this amount, okay, quite a big amount actually, okay, for the year 1930s here, all right. Payment for as a compensation, okay, that's the amount of money, all right, offered. So, all right, the company knows about whatever Mr. Bell had been doing later. I mean, after Mr. Bell accepted their offer, okay. So the issue when the case was brought to the court, okay, the issue was that, okay, whether the redundancy, okay, the compensation contract lah, basically, that was created and accepted by Mr. Bell, okay, could be void for common mistake. Because why? Due to later finding out about his personal trading. So the company did not want to proceed, okay, with the payment of compensation. So they said, well, we made a mistake actually. Okay, we don't know that actually you had some personal arrangement which is against, okay, the company's policy. Okay. But this is decision by House of Lords. But this is not unanimous decision. Okay, this is majority decision. Meaning here we have dissenting judgment. All right. So the majority, okay, of the lords here, House of Lords, right, was the contract was not void. This is the decision, okay, because why? The mistake was not an essential and integral part of the contract. They said, well, the mistake was there, but then it doesn't really affect the contract, not essential part of the contract. And after all, the personal trading had happened during the employment and it's not really related to the subject matter of the contract, okay, which was said to be minor compared to the profits Mr. Bell had made for Lever Brothers. So that's all the consideration by House of Lords here. Okay, right? And then the relevant part for our discussion, okay, House of Lords said that the mistake actually was to the quality of the employment contract. So it doesn't go to the root of the contract. It doesn't affect the whole compensation agreement here. And because of that, it did not nullify their consent to the compensation contracts. Okay, so the offer was still valid and then has been accepted by Mr. Bell. Okay, the last one, mesti with regards to the possibility of performing the agreement. Okay, we have the case of Shea Brothers Limited and Oshner. I think this case is from Africa. Okay, all right. So this is the appeal case. I think decision by Privy Council. Okay, all right. We have appellant. Okay, company. Appellant was the licensor, and the first respondent here was the licensee. And the license was regards to authority, okay, to do what? To cut, okay, to process and manufacture all sisal growing on certain lands in Kenya. Okay, what's sisal? Okay, that's the meaning lah, sisal. I think in Malaysia, it is quite similar, all right, if not the same. We call it as mengkuang, okay, all right, the one that we use to produce mat, okay, all right. Okay, so we go to, this is the case from Eastern Africa. Okay, so by a license agreement, okay, the appellant granted to the first respondent the license, okay, and authority, okay, to cut, to process, to manufacture, okay, all the sisal plant, okay, growing on certain lands in Kenya. So the licensee undertook, okay, promised that he would manufacture and deliver, okay, for sale to the appellant all sisal fiber. So this is the quantity, okay, in average minimum quantities of 50 tons per month. So that was incorporated into their licensing agreement. But later, they have problem. They have disputes. Okay, all right. So later they had disputes. So disputes between them, okay, the appellant and the licensee were referred to the arbitrators. And the relevant part, okay, one of the issues, okay, the question raised was being, okay, whether the agreement was filed under Section 20 of Indian Contracts Act, okay, which is identical to Section 21 of Malaysian Contracts Act, okay, by reason of mutual mistake. Is it a case of mutual mistake? Okay, on the fact that both parties, both licensee, okay, they believe, okay, contrary to the fact that the lift potential of the sisal fiber would be sufficient, okay, to permit the manufacture. They thought they are able to produce this quantity, okay, the 50 tons is now, but actually it doesn't. Okay, all right, it doesn't. It's not really sufficient. Okay, so the court hold that, okay, the court actually look at all the terms of the agreement, okay, consider it thoroughly, closely, okay. So the court said, well, actually, from the contract here, it was the very basis of the contract, is the root, okay, is the foundation of the contract, that the sisal area, okay, should be capable of producing average of 50 tons a month, okay. So when the licensee, when the licensee was not able to produce this quantity, okay, basically it invalidated the contract. Okay, all right. So the mistake here was as to a matter of facts essential to the agreement with regards to their performance, okay, ability to perform the contract, ability to produce, okay, certain amounts of sisal fiber per month. Okay, all right. So I want to stop here. So we are going to cover the last part of our topic, okay, in my next Zoom recorded lecture. Okay, let's stop share. Stop here. Okay, thanks a lot for listening. So I'll see you in the later part, okay, of our lecture. Assalamualaikum warahmatullahi wabarakatuh.